And in that sense, it will seek to defeat the purpose for which CI 87 and CI 47 were made. And from research, it could be seen that delay in trial largely emanates from viva voce evidence in chief. It is viva voce evidence in chief. Because cross-examination, you are already in the box. But viva voce, you will introduce something, an objection may be raised, and whenever such objection is raised, what the person will do is that I'm asking for a date. Then the next morning, the person files application for amendment. If he files application for amendment, it is granted, it is amended. The other side will take advantage. So if you look at a process which would have been done within a day, it will take about 4-5 months. And that brought about CI 87, the witness statement, to cure the defects. Then Ghana, following United Kingdom, Canada, India, and Nigeria, because they had started witness statement and were found to be fruitful and efficacious. So what happened was that in 2014, Ghana came out with CI 87 to amend Order 32, 33, 38 of the High Court rules to introduce witness statement and few other things. We cannot talk about witness statements without having a look at application for directions. Application for directions, as we know, has dual purpose: to ensure that all pending applications or applications that have been dealt with are dealt with at that stage. Then the second rule is to give the future conduct of the matter. So all pending applications will be dealt with. And that is where the future conduct of the case will also be determined. Now, with the application for directions, we know that it has exempted some areas of law. We talk about Order 11, Rule 18. It is one of them. It has been exempted because striking out pleadings, if it is struck out, there's no need going through application for directions. The only mistake is that the lawmaker, instead of quoting Order 11, Rule 18, Order 11, Rule 19, he said 18. It is just a minor mistake. Now, we also take into account where a summary judgment is obtained and an application is to be made for future directions. That one, it is done at that stage. You don't go through application for directions. Then we also talk about few other things, such as accounts where an order for account is made. You don't go for application for direction. So these are the few exceptions, and particularly Order 65, matrimonial causes, where application for direction is not taken because it is not one of their processes. Now let's look at case management. There are two alternative major functions under case management, which is an effective tool to regulate hearing of a matter after the application for directions has been filed. The first function helps the court to give directions for the management of the case and further provides for a timetable to regulate the processes to be filed and directions for trial. That is where we take the timetable. We know the timetable. This is how we are going to determine the matter. We shall visit locals. We are appointing experts. All these things are dealt with. Then the alternative function empowers the court to fix a case management conference and give directions regarding the management of the case as the court will deem fit. Where the court chooses the first option, it may set down a matter for a preliminary legal matter to be determined under Order 33, where we are talking about capacity, jurisdiction. There will be case management, but we will not have case management conference. Case management, you set the matter down for trial, it is determined. Those that can be determined, either legal matters, factual matters, combination of legal and factual. These two can be effectively determined at that stage. And in that sense, you do not pass through the case management conference. The court may take evidence in respect of preliminary issue and resolve them. Where the court chooses the second option, that is, it shall order for witness statements to be filed by the parties and their witnesses. And when we talk about a witness statement, we are referring to a statement that a person who will testify in that case, a statement that a person would be permitted to give orally. If you will not be allowed to give it orally during trial, then it will not constitute a witness statement. The witness statement may be filed by the parties simultaneously or at different times, as the court may determine, in the interest of justice, and depending on the nature of the case. The parties shall file their respective pre-trial checklists after having filed their respective witness statements in accordance with directions given by the court at the application for direction stage. The court may here either set a date for a case management conference or may have a pre-trial review. There is a difference between a case management conference and a pre-trial review. In practice, a pre-trial review is held in complex cases to ensure that trial proceeds efficiently, and the court is required to identify the dispute in the matter and narrow it as far as possible for easy resolution. Some of them, you see that the matter is compressed. You must narrow the issue. That is where you may need the scale to conduct pre-trial. Let's look at case management. Case management requires the court to prepare the case for trial. The role the court performs at the case management conference is to ensure compliance of its orders, made at the application for direction stage, such as filing of witness statements, express reports, disclosures, helping the parties to resolve the dispute by any of the ADR mechanisms, and fixing of timetables. And when we talk about case management, it varies from one country to the other. That was the mistake that we committed. Case management varies from one country to the other, depending on the rules of that country. In the United Kingdom, the court is seized with jurisdiction to undertake case management conference, sets a timetable to take care of all the steps in the trial. The court may have a number of case management conferences in one case, depending on the nature of the case. In the UK, they can have about 7 or 8 conference management in one case. In the United Kingdom, the purpose of case management conference is to ensure that the court identifies the issues in the matter, takes a decision as to whether those issues could be narrowed before trial, and finally to make appropriate directives for the parties to enable the court to effectively manage the case. A look at their civil procedure, their practice direction 23A civil procedure rules expatiated. Then in Ghana, however, a case is fixed for case management conference for the court to give directions regarding the management of the case as the court may deem fit. The case management conference helps the court to ensure that all orders made by the court at the application for direction stage, including filing of witness statements, disclosures, have been complied with, and pre-trial checklists have been duly filed in accordance with law. Order 32, Rule 7A, 1B of CI 47, as amended by CI 87. The English position on case management conference is not the same as Ghana's, as most of the directives given by the courts in England are normally made at the application for direction stage in Ghana. In Lagos, because we have to demonstrate that case conference management is sui generis. It is with particular country. In Lagos, Nigeria, within 14 days after close of pleadings, the plaintiff is required to apply for case management conference to be issued under Order 25, Rule 3, High Court of Lagos State Civil Procedure Rules 2012. The Lagos rules provide for sanctions to be imposed on parties who fail to attend case management conference in good faith. Where the plaintiff fails to participate in the case management in Nigeria and it is not made in good faith, the plaintiff case shall be dismissed by the court or the case management. In the case of a defendant, the court shall, in appropriate cases, enter judgment against the defendant. Order 25/5 of High Court of Lagos State Procedural Rules 2012. The judge is required to make a report of the conduct of the case management conference to provide for the roadmap to regulate the trial, and therefore it is mandatory to attend. And if you fail to attend, you are sanctioned. And the sanction is serious. Under CI for the power vested in the court to enter judgment in favor of the plaintiff, where the defendant fails to attend case management conference in good faith. The court is only clothed with jurisdiction to make any of the following orders, where the order made at the case management conference is not complied with. Here, the important thing we must note is that at the case management conference, the court is only competent to ensure that processes have been filed and they make some orders. But if they are not complied with, the court is not clothed with authority to sanction anybody. The time for sanction is after the court has fixed a date for hearing. The court is only clothed with jurisdiction to make any of the following orders, where an order made at the case management conference is not complied with and not at the case management. A, strike out the plaintiff's case for non-compliance. B, strike out the defendant's defense and counterclaim of the defendant if the defendant is the non-complying party. Then 3, order a party to pay costs. And D, make any other appropriate order. So here, that was where we fell into a deep ditch. Because we borrowed from UK, we borrowed from India, Nigeria, Canada, without taking into account that our provisions are not the same as that of England, as the same as that of Canada. The rules of evidence on admissibility and objections. If we look at our Order 38, Order 38 is on evidence during trial. And Order 38 specifically states that subject to the Constitution, evidence, and any other enactment, the rules of procedure provided in CI 47 shall prevail. The word there is subject to. That means it is limited to. So where the Constitution provides otherwise, the Evidence Act provides otherwise, any other enactment provides otherwise, we must follow that one because it says subject to. Then we look at our laws too. Let's look at our Article 11, sources of law, because I've come across a decision who says that Article 11 has been arranged in a hierarchical order. It is not true. The Constitution is the supreme law by virtue of Article 1, when it says that I am the supreme law, but not Article 11. Because can we say that? Let's take the Legal Profession Act 32. It's a substantive enactment. It is an existing law. But LI 2324, it was made just 2020. Can we say that LI can supersede or override an act? That has never been the law. Because the law is that when we arrange law hierarchical, you move from the Constitution, then you talk about all acts of parliament, whether existing law or current, it is immaterial. Then we move to delegated legislation, then common law. Now, the mistake that we did was that we deferred to what is in the procedural rules, CI 47. Because where two laws are in conflict, we must look at the two laws, where they are of the same character. If they are acts of parliament and they are two, and they are in conflict, that is where we talk about where one of them is a general law and one of them is a specific law. That's where we talk about generaria specialibus non derogant, meaning where we have two acts, the two acts are in conflict. If one of them is general, one is special, then the special shall override the general. Then we also take where they are of the same character, maybe acts of parliament. The two of them are special legislation, such as we talk about Cause Act and Matrimonial Causes Act. Both of them are special enactments. In that sense, what do? We use leges posteriornis pronis contrary abrogam, meaning where laws are of the same kind, then we use the latter one. So it doesn't matter whether it was an existing law or act made under 1992 Constitution. Now let's look at our pitfall. Our pitfall was that Section 6 of the Evidence Act is a substantive law. Then CI 87 is procedural, and the substantive law is an act, and the CI is derogated. So always the act overrides the derogated. And here they are in conflict. Instead of calling for an amendment of Section 6 of the Evidence Act, we decided to follow practice in other jurisdictions. But if you look at Order 82, Rule 1, it says that where rules are not provided for a matter in the procedure, then we may resort to practice in common law jurisdiction. Therefore, where a procedure has been prescribed, you must use it, whether you like it or not. That is what you have. But we decided to follow particularly India and England. And we decided to use case management conference to decide on admissibility, relevancy, inadmissibility. That was the error that we committed. Let's look at case management conference. The law provides that at the case management conference, we look at compliance, ensure that orders made and directions have been made. Then we give roadmap. If the roadmaps are not complied with, we cannot sanction at that stage. We can sanction during trial. But we decided to use case management as part of the trial. But case management is pre-trial stage. It is not part of the trial. And Section 6 of the Evidence Act provides that an objection shall be raised at the time the evidence is being offered. So here, it was premature. We determined evidence at case management. Meanwhile, Section 6 of the Evidence Act, which is a substantive law, says that objection shall be raised at the time it's being offered. And what is the time? The time is during trial. Then the second one that we did not have a second thought was that we looked at the objections. At what point in time can you raise whether an objection is admissible or inadmissible? Somebody must be in the witness box. But at the case management, who is in the witness box? There is nobody in the witness box. So how do we determine admissibility and inadmissibility when we have Section 6 of the Evidence Act unrepealed? So the problem was caused by us. And that is the... So from the above discussion, the Evidence Act, in substantive law, takes precedence over the High Court civil procedure rules. And once the Evidence Act provides that an objection to the admissibility of evidence shall be raised at the time the evidence is being offered, then it is that stage that such an objection must be raised, and not at the case management conference, which is pre-trial. And secondly, there is an impediment by virtue of Section 6 of the Evidence Act. And the third one, there is nobody in the witness box for the person to tender for such an objection to be raised. The orders to be made by the court at the case management conference are limited to ensuring that orders made in respect of filing of witness statement disclosures have been complied with, and we give further directives on the future conduct of the case. That is all. Now, there is another law which I've seen a judgment which needs to be addressed. Court expert, Order 26 of CI 47. If we have a look at Order 26 of CI 47, it provides for court expert. Court expert, there's a difference between an expert witness and a court expert. Court expert is an expert called by the court. Court expert is an expert called by the court. Then we talk about here, if you look at Order 26, it says that where a court expert is appointed, the court expert submits his reports to the court. And a person who seeks to cross-examine does not file a motion to the court. After 14 days, it will be deemed to be evidence. You know, that is the position in CI 47. How can that happen? Because we have Section 6 of the Evidence Act, which says that evidence must be tendered. An objection may be raised at the time. Now, if you file within 14 days, no objection is raised, Who is in the witness box? There's nobody in the witness box. So please, when we are using order 26, we should have in mind that it violates section 6 of the Evidence Act. If an expert is called, the expert submits report. So far as we continue to have section 6, the expert must come to the witness box to give evidence. It is at that stage that objection can be raised. Let's look at section 6. Is there a need to amend it? Until section 6 of Evidence Act is amended, an objection to admissibility of any evidence, including exhibits, should be raised when a party is in the witness box and that evidence is being offered, and not at any other stage of the proceedings. Case management does not constitute part of the trial of a case, and an objection to the admissibility of evidence cannot be determined at that stage. A witness statement, let's look at its legal effect. I will wind up soon. A witness statement is the statement in writing by a person and signed by that person containing the evidence the person will be permitted to give orally at the trial. So here, if at the trial, the person will be permitted to give that statement orally, then it will constitute a witness. A witness statement shall be verified by a statement of truth by the person who made it to prove that it contains the evidence that the person will be permitted to give orally at the trial. Order 38, Rule 37C of CI 47 as amended by CI 87. It will not be permitted to give oral evidence. A witness statement shall not contain anything which the person who signed will not be permitted to give it orally as evidence at the trial. Therefore, a witness statement shall remain a statement until it is adopted by the court at the trial after it has passed the admissibility test. The court has the power to reject a witness statement or part of it as inadmissible when the person who made it and wishes to rely on it as that person's evidence in chief has been sworn by the court and impliedly pray for the conversion of witness statement from statement to evidence in chief. Because we know that when the person is sworn and it is tendered and no objection or it is corrected by operation of law, the witness statement automatically converts from a statement to evidence in chief by operation of law. Similarly, where a person who made a statement is unavailable and that person's witness statement is to be put in as hearsay evidence, the court may allow it subject to expunging any part of it which is inadmissible, and that person would not have been allowed to give orally as that person's evidence in chief at the trial, because that will be your evidence in chief. If it contains something that ordinarily wouldn't have passed the admissibility test, then if the person is unavailable, that one too should be expunged. And we know that inadmissible evidence can be expunged at any time, even during judgment and on appeal. The court may also allow a person who has filed a witness statement to give additional oral evidence in respect of a new matter. This one is limited to a new matter, which has arisen since the witness statement was filed and served on the other person. The court may grant such leave to the party to give further evidence in chief orally, where the court is satisfied that there is good reason and not to restrict the person's evidence in chief to the witness statement of that person. Order 38, Rule 3E, 3 and 4 of CI 47 as amended by CI 87. By parity of reason, the court may grant leave to a person who has already filed a witness statement to file and serve a supplementary witness statement, where the court is satisfied that it should be granted in the interest of justice. And another thing we must take into account is that we continue to have Order 16, and the rules on amendments are still there. So amendments can be made at any time, provided it is in accordance with law. After objections to admissibility of a person's witness statement have been determined by the court, the admissible part shall stand as the evidence in chief of that person. In conclusion, a witness statement shall become the evidence in chief of the person who signed and verified it by a statement of truth at the trial, and not at any other stage by virtue of Section 6 of the Evidence Act, which provides that an objection to the admissibility of evidence shall be determined at the time the evidence is being offered. The case management conference is part of the preparatory stage of a trial and does not form part of the trial. And any trial or purported trial made at that stage shall be void. My colleagues, so the problem emanated from the court and the practitioners. We failed to take into account our CI 87, and we failed to appreciate that it is sui generis. It was made for Ghanaians. Vis-a-vis CI 47 and 87, they were made for Ghanaians. And where we have laws, there wasn't any lacuna, but we abandoned ours and used the rules in other jurisdictions. So the only solution is that if we want to make effective use of the case management to be part of the trial, then we should take steps to amend Section 6 of the Evidence Act. Thank you very much for your audience. I told my sister moderator that I've been down throughout the day. And the reason is that I was coming with my brother and friend Mafusan. We had arranged to come. And unfortunately, he passed on. May his soul rest in peace.
Thank you very much, Justice Dennis Adjei, for educating us on the subject of witness statements. Colleagues who are joining us virtually, I'd be grateful if you'd post your questions in the question and answer box. Sir Dennis will take questions at this stage. We'll take 3 questions at a time. So if there are any questions, the floor is open, please. The microphones are in front. You walk up to the microphone and you identify yourself. Thank you. Sir Dennis, there are some questions in the question and answer box. So there are 2 of them, I'll read them. The first is, what happens to all cases that have been conducted with objections taken at the case management stage? My lord, did you get that? Okay. Then there's a second question from Frederick. There is a view by some judges that the witness statement must be signed separately from the statement of truth. Until recently, I've always let my witnesses sign only once. Can you throw some light on this controversy? My lord, did you get the question? The second.
The first answer, we know of.
My lord, if I may interrupt you small, I have a question which is in connection with the first question.
All right.
The witness statements that are filed, they are filed together with exhibits that will be tendered during the trial. And then objections are not raised during the case management conference. And so usually they are binded together, whether in a booklet form or a combined form. And it's observed that all the 3 or 4 witnesses, their statements are in a booklet form. And at a time the plaintiff is called to open his case, it is offered. And so at that point, do you wait? And usually all of them are brought together in that section or process, or all the witnesses' statements are filed together and they are lumped together and they are brought to court as the evidence in chief together with their exhibits. At that stage, do you raise objection as to some of the exhibits and then how it can be done practically? Thank you.
Good. Section 6 of the Evidence Act will not permit any court to decide admissions at the case management because it is not part of the trial. So that one, the answer is straightforward, direct and straightforward. Now, when we come to the cases that have been determined, if cases have been determined and the errors committed did not go to the root, it will be a Friday. And no court would allow all proceedings which have been validly determined under those circumstances be nullified. That's why we are going to create anarchy. But if it is If it is in the process, that is where an objection may be raised, as happened in the Republic versus High Court Commercial Division, Accra, as party cabinet before. Republic versus High Court Commercial Division, Accra, as party cabinet before. Attorney General and others, interested parties. Civil motion number J5/05/21, delivered on 10 February 2021. Supreme Court unambiguously stated that no question of admissibility can be made at the case management. It resolved that one. Then when it comes to putting your signature on the witness statement and the verification, here we are just, it is not very important, because once you have signed your witness statement and you have verified it, that is all. But I have come across some cases where the witness statement has not been signed, but there is a verification that this witness statement was signed by me and I verified that it is so and so, so and so, so and so. And here I've seen some courts that will order that you should go and prepare a new one. If I were confronted with such an issue, what I will ask myself is, first and foremost, what is the importance of verification? You are verifying the content of the witness statements. But for the avoidance of doubt, sign the two. Because after all, it won't take anything from you. Sign the witness statement, sign the verification. You don't lose anything.
Sir Dennis, please, my question is with respect to.
Kindly wait to be called to the podium. So identify yourself, please. Yes.
My name is Margaret Hammond.
Okay.
My question is with respect to joint trial. At what point do you treat a witness as an adverse witness or a hostile witness? Because when it was Viva Voce, it was easier when you realize that your witness is going off or has changed their evidence. So you tell the judge that this is what you are doing. But then now that it's a witness statement, you would realize that during cross-examination that they are moving away from the evidence that they might probably have given you. So at what point will you indicate that you are treating that particular witness as an adverse witness or a hostile witness? Thank you.
Thank you. Is that, yes, sir.
Thank you. My name is Kennedy Efa. My question is on cross-examination of documents attached to witness statement yet to be tendered, though filed. So what happens to that? Assuming you want to cross-examine on a document that is attached to a witness statement yet to be tendered, I want to know the position on that.
Thank you very much. Is there another question, please? Yes, sir.
Thank you. My name is Anthony Edunketia, aka Tony Short. My Lord, you mentioned that supplementary witness statements may be filed by leave of court. I have seen instances where judges also insist that you withdraw what you filed earlier and then refile the whole witness statement. Which of the two should be the case? Thank you.
The last question from the floor, please.
My name is Godwin Mentosaki. Please, my question has to do with the practical effect of putting in witness statement which has been objected to. So if a part of witness statement which has been put in and objected to, and the court rules that that part of the witness statement should be maybe struck out, what happens to it? What do we do with that document? Is it that the court would ask that a new witness statement is brought in? Because obviously if a part of the witness statement is struck out, you don't want it to be in the record. So what do you do with it? Is it going to be deducted, or is it going to be crossed out? How do you do it practically in a way that it has not become prejudicial in the document for the purpose of appeal or anything of that sort? So practically, what happens to it?
Okay, thank you very much.
Thank you. Let me start from the last one. You have 6 paragraphs, witness statements. Objection is raised. paragraphs 1, 3, and 5. Objection is raised and they are upheld. The judge will write, paragraphs 1, 3, and 5 of the witness statement are hereby expunged from the records. Now we have only paragraphs so and so as part of the witness evidence in chief on record. It doesn't change anything because there is a recording to that effect. Like if Supreme Court strike out any legislation, do they take pains to cancel all of them? You don't do that. Once it is pronounced and there is an entry to that effect, it operates. Then supplementary witness statement. The law itself provides for supplementary witness statement, particularly where new matters arise after the filing of the statement. So once that has been provided, the judge cannot say that he will not allow you to withdraw and go and file another one. If it is criminal, then the law permits amended. That one, it is clear in the practice direction. But this one, CI 87 itself provides for filing of supplementary witness statement, but it might be filed with the leave of the court and not as of right. Then we talk about cross-examination on documents attached to when the person is in the witness box and we determine the admissibility of the witness statement. We do the same thing to the documents attached to that evidence, to the same statements. 1, I object to 1. It is determined. It is admitted. Then the third one, it is inadmissible by virtue of so and so is hereby marked as R1. R1. It is rejected. So at the end of the day, you determine those to be admitted and those not to be admitted. The fact that they are filed together, that doesn't mean that all of them should go through. We take them one by one and determine. Then the other one on how do we now determine witness state, hostile witness, unfavorable, and those types of witnesses. You know, it is a very gray area. Because what we know traditionally is that where I am calling you, and I know that from the onset you are coming to lie, and your evidence is material, and if I don't call, the other side may use it, then I will call you and inform the court at the beginning that I am going to use this statement that this person is to be considered as a hostile witness. Now, if somebody is hostile and the person says he will not file statement, at the case managed, at the application for direction stage, you inform the court that this person shall be called and that person's evidence shall be taken viva voce. So it hasn't changed. You can still take advantage of that position. Because ordinarily, when we talk about a hostile witness shouldn't have evidence in chief. This evidence starts from cross-examination. If the person is maybe unfavorable, the person may have evidence in chief, cross-examination. You have called the person. The person is telling the truth, but his evidence is unfavorable to your case. So the law has not changed. If the person is hostile and you know that the person will not tell the truth, at the application for direction stage, it is part of the things that you do, the future conduct of the case. We discuss all these things over there. That is why where the court will go to locus, we discuss all of them at that stage. Where you call experts, we discuss all of them at that stage. So at the application for direction stage, we should do thorough work. We shouldn't be just we join issues and we end there, because it is the roadmap that gives us the future conduct of the case, and it hasn't changed the law. It's just a matter of informing the court, and that's why we take the evidence viva voce. Thank you.
Take the next set of questions from the virtual participants. What law supports the application of witness statements in criminal trials? Then Benedicta will want to know what happens to a witness statement after the person who swore it had passed and the person has been substituted for the matter to proceed. Then Frank would like to know if it is affidavit evidence in support of a motion where a piece of evidence is found to be inadmissible. How can this be objected to since no one will be in the witness box? Then the final one, some would like to know if you are obliged to disclose evidence intended to be used during cross-examination to confront a witness at case management. So are you obliged to disclose evidence intended to be used during cross-examination to confront a witness at case management?
As aforesaid, at the case management, we don't do any trial. We look at the orders made at the application for directions, whether they have been complied with, and then we continue with the roadmap. That is what is done at the case management. So at the case management, we don't talk about cross-examination, evidence in chief, and those things. We don't do them at that stage. Then there was a question, affidavit evidence. As he said, it is not a witness statement, it is affidavit evidence. If you swear to an affidavit and it contains falsehood, we can commit you for perjury. So when we talk about witness statement, if a witness statement is commissioned, it ceases to be a statement, it becomes evidence, and you cannot use it at a trial. It's a different thing altogether. Once it is an evidence, it remains evidence. It is not a statement, but it must be a statement. Then objections are made before we go through. But if in applications, normal applications, you have filed something and another has opposed, and you think that something is inadmissible, you raise it and the court takes arguments from the two and the court rules. Then the next one is about
what happens. So it's about what happens to a witness statement after the person who swore it had passed and the person has been substituted for the matter to proceed.
Not recently, I read an interesting article where somebody, it wasn't a peer-reviewed article, I read it from one of the webs, where somebody was arguing that he had a matter, he was stating that he had a matter before the court. When they went, the party had died. Then the substituted plaintiff wanted to use the witness statement of the deceased person. How can you do that? It is not your evidence in chief. If the person who made the witness statement has died and you need to substitute the person, you may substitute the person. If you want to use the statement under the hearsay rule, you can use it. If you don't want to use it under hearsay rule and the substituted party would like to give his own evidence, then he must file his witness statement with the leave of the court. Because in practice, can we say that somebody has given evidence in chief? Then another person comes to the witness box to be cross-examined for and on behalf of that party. It is not done. It is what we do in practice. That is what we are just translating into the witness statement era. So that is how it should be.
We'll take one more question, the final one from the floor and one from our virtual participants. So if there's a question from the floor, well, if there are no questions from the floor, then somebody wants to know where a defendant elects not to present any witness and by inference evidence, what happens to the orders of the court for case management? Secondly, in that instance, will the court strike out the defense of the defendant for non-compliance? So yours will be the last question, please. Thank you.
Thank you very much. Araba Sika-Abedi. My question is this, a similar one was asked earlier, but I think the answer doesn't really address the nature of the question.
All right.
In a situation where a plaintiff tenders his witness statement, and then there's cross-examination now of the plaintiff, but then there are certain exhibits that are within the witness statement of the defendant, which is yet to be tendered. The question is, that exhibit or document is not proper evidence before the court because it hasn't been tendered. So what is the procedure when you want to ask certain questions based on those exhibits attached to the witness statement of the defendant? Thank you.
Good. The remain statement. Oh, sorry. If you're asking a question.
The very last, please. Thank you.
Respectfully, my name is Janet Asari Bobi. My question is, my lord, if you have about 50 plaintiffs or defendants, should all of them file their different witness statements, or they can file one witness statement? Thank you.
First and foremost, when we talk about a witness statement, one witness statement is supposed to be filed by one person, because you cannot tell two persons to be in the witness box at the same time. But nothing prevents 50 witnesses or 50 parties by saying that give evidence for yourself and on on our behalf. But if they decide to file a statement each, it is permissible. They can file their own statement, but no two persons can file one witness statement. Else we have to put the two in the witness box at the same time, which is not permissible. Then the question about the exhibits, if I heard you well, if a person files statements and the person files documents, they remain documents until they pass the admissibility test. They remain documents. So in practice, before we had the witness statement, where you had documents coming from the other side and you wanted to make use, nothing prevented you for you from tendering that piece of document as your exhibit so that we can take advantage of that. But if you decide that you are going to cross-examine a party on a statement that is not in evidence, that one, it varies rules on evidence, because it must be in evidence before the person can be cross-examined. Then the other question, where a person fails to attend case management conference. If you fail to attend, what the court can do is to adjourn the matter for a hearing. And if you are a defaulting party and you haven't filed, CI 87 has provided a clear-cut answer that at that stage, the court may either grant leave orally to the person or the court may strike out the person's case. That one, it is the prerogative of the court. But where they have given their evidence in chief, you have cross-examined and you think that they haven't made any case against you, you can make submission of no case. So any one of the two is available.
Thank you very much, Sir Dennis, for the time and effort in putting together the presentation and for enlightening us. It's been such a pleasure listening to you. Thank you very much. We wish you all the best in all your endeavors. And dear colleagues, we are very grateful that you joined us. It's been such a pleasure for me and an honor moderating this session. Kindly join the next session at 3:30 p.m. Thank you all very much. God bless you and stay safe. And let's clap for Sir Dennis, please. Thank you very much. He's one of our frequent speakers.